Hello everyone, welcome to my channel. Today we are going to see the topic on punishments. Punishments in Indian Penal Code. What are the ways in which punishments can be given? What is the discretion of judges? And whether India supports death penalty or not. These are the most important topics that we are going to see. And if you are preparing for UPSC, law optionals, or any other examinations for the matter, for judiciary, UGC net, this is going to be of immense helpful to you. So without further time for delay, I'll straight away go to the topic. First, we have to see various theories of punishment. The various theories include deterrent theory, preventive theory, retributive theory, and reformative theory. And if you want me to go ahead and straight away give an answer which is the best that has been advocated by the Supreme Court, it is the reformative theory. Before explaining reformative theory, let's see what are the other three theories. Deterrent theory talks about a form of punishments where you create a deterring effect on an individual, which would make him not to repeat the crime. For instance, if a person has stolen something, deterrent theory of punishment means it should ensure that the particular person does not steal again. Now, preventive theory is very similar to deterrent theory, but preventive theory has slight fine difference in the thing that, say for instance, if a person has stolen an article, but according to deterrent theory, he should not steal again. This is the idea. Preventive theory means preventing the same person from committing other crimes like violence, murder, etc. Retributive theory is the classical theory which was followed in the criminal judicial system from time immemorial. That is, simply put, it's a kind of revenge or an eye for an eye. Now, various studies have proven that all three are ineffective for the betterment of the society, because in criminal laws it is the betterment of the society, it's the betterment of the individual that is of paramount importance. So various studies have proven that these three are ineffective, and the best method would be reformative theory. Reformative theory simply means you should need to reform the individual. If he is a criminal, you incarcerate them, reform him, and ensure that he would be able to be reintegrated into the society. Preventive theory simply means preventing the wrong from happening again, and preventive theory is very similar to deterrent theory, but here the subtle difference is that in preventive theory you ensure that the person does not commit any other form of crimes or type of crimes, like from stealing to murder, etc. Whereas deterrent theory is something where you stop the person from stealing again or murdering again. Retributive theory, it's kind of revenge, an eye for an eye, which has no place in the society, and it is proven to be ineffective. Reformative theory, that is the most important theory, and Supreme Court also advocates that the objective of punishment in IPC should always be reformation, that is reformation of criminals. In the Narottam Singh case, Supreme Court reiterated the principle that reformative theory should be the objective of the punishment under Indian Penal Code. Now, you must also be various jurists have told that just because there is a reformative theory, reformative theory doesn't mean that hardened criminals are let scot-free. It's not like that. There must be proportional punishment. Punishment must take into account the gravity of the offense, but it is not something that has aspects of retribution kind of things. ultimately the goal must be that if the person can be reformed, he can be reformed and he has to be reintegrated into the society. And just because there is a reformative theory doesn't mean that you have to be lenient with certain grave crimes or with repeat offenders. So what matters here is the reformation of the individual. And in the state of Maharashtra versus Surendra Singh, Supreme Court has told that because there has been wide discretion. If you look at Indian Penal Code, usually the punishment will have a maximum sentencing, like say for instance 10 years of rigorous imprisonment. This would be given, but it doesn't mean that the person has to go through 10 years of rigorous imprisonment. He might be given 6 years of rigorous imprisonment if there is any mitigating circumstances in which he has committed the crime. So, but whatever it is, what is important is the punishment should be proportionate and adequate with the gravity of the offence. Section 53 of IPC, Indian Penal Code, gives these types of punishments in our country, that is death, imprisonment for life. Yes, India still has death penalty, although the Supreme Court has said that it would be implemented only in the rare of rarest circumstances. So rare of rarest, what is this doctrine, in which case law it has been propounded, we'll be looking at it in later slides. But for now, the types of punishment, that is death, imprisonment for life, imprisonment with rigorous hard labor, imprisonment with simple labor, forfeiture of property and fine. So these are the types of punishment that has been given in Indian Penal Code. Now of course, transportation for life, whipping, all this was present in the code, but now it is not there. This has been done away with. This has been done away with. Now let's come to the death penalty. There are certain sections where death penalty has been given as a form of punishment along with imprisonment or along with other punishments. So it is up to the judge to determine whether death penalty has to be given, but provided this has been incorporated in the act itself. Waging war, murder, kidnapping, dacoity, and even under POSCO Act for child rapists, death penalty has been given as a form of punishment. Mind you, it is not only the death penalty. There are other forms of punishment that is given, but it depends on the gravity of the offence, or what is called as rarest of rare. What is rarest of rare? There is no straitjacket formula. It depends upon the facts and circumstances of the case. But in the case of Machi Singh versus State of Punjab, these factors has to be taken into account before concluding a crime as a rarest of rare, that is method of commissioning the crime, character of a victim, intensity of the victim, and crime deserving hatred in the society. So all these things can be, if all these things were present, then say for instance if there is a murder has happened in a glorifying manner in intensity which is higher, which is absolutely considered unacceptable in a civilized society, then the judge can determine it to be grave or rarest of rare and award death penalty. Mind you, in India death penalty there is always a possibility of pardoning. So death penalty can be pardoned under Article 72 and Article 161. So if Article 72 is for president and 161 is for governor. So they can pardon the death penalty. Now under Article 72, a president might give a reprieve, respite or even commute. So reprieve means temporarily suspending a death penalty. Respite means postponing the death penalty to a future date. commuting means changing the death penalty into imprisonment. Now, commutation of death sentence can also be done by the appropriate government. This is given under section 54 IPC. Appropriate government means if it is a crime that is related to union government, then it would be the union government, or if it is related to state and laws made by the state, then it would be the state government. So even the appropriate government can commute a death sentence without hearing the offender. So it is up to the appropriate government. And also under 71 and also under article 72 and 161, pardoning power has been given to president and the governor, but the Supreme Court has clearly said that this power has to be exercised under the aid and advice of the Council of Ministers. So if there is the aid and advice of the Council of Ministers, then if the governor or the president has to follow the aid and advice, they cannot go against that. In essence, in short, it is a discretionary power with president or governor, which means that discretionary power is the discretion of the Council of Ministers. Council of Ministers. There are certain times where the president have gone against the advice of the aid of Council of Ministers, and for some instance they have not, and still this is a developing jurisprudence, but the overarching idea is that they have to abide by the decision given by the Council of Ministers. Recently, even the Supreme Court gave this verdict in Nalini case. Rajiv Gandhi, India's former Prime Minister Rajiv Gandhi's murder accused. Now, what are the grounds in which death sentence can be commuted? In Sher Singh versus State of Punjab, delay in execution of death sentence was not considered to be a grounds for commutation. This was the first case, but after that, in various other cases, the court have overruled this, and they said that in GB Singh versus State of Uttar Pradesh, they said that undue delay can be a ground for considering for commutation if there is sufficient facts and circumstances proving that there was an undue delay. Again, this is all depending upon undue delay. But recently, in Charan Singh case, also the Supreme Court has said that inordinate delay where there is no reasonable justification can be grounds for commutation. Next, another important topic is the mercy petition. I told you mercy petition can be decided by President under Article 72 and 161, and in Supreme Court, in the case of Yaqub Abdul Razak Menon versus State of Maharashtra, has clearly indicated that mercy petition once rejected, there is no inherent right of the person to get it reviewed or revisited again. If the President determines to look into a rejected mercy petition, then it is fine, but there is no hardened rule that the President must revisit the rejected mercy petition. We have to see commutation versus remission difference. Commutation means, say for instance, in the example of death penalty, commutation means changing the nature of the punishment from death to imprisonment, while remission means reducing. Say if it imprisoned for 10 years of rigorous, remission may be 5 years of imprisonment. So that is the difference between commutation and remission. Imprisonment for life means for the whole of a person's natural life. Of course, there is section 57 which says that imprisonment can be equivalent to 20 years, but this is not a right. It is up to the appropriate government to determine whether to release a person after 20 years or not. So imprisonment for life means imprisonment for the whole of a person's natural life. And in the case of KM Nanavati case, it was held that imprisonment of life means rigorous imprisonment and not simple imprisonment. And another factor which is form of punishment given in IPC is the fine should not be excessive. Next, there are other kinds of punishment, that is solitary confinement for imprisonment. But if it is a solitary confinement, the maximum amount of time in a person can be held in solitary confinement is just 3 months. With this, I conclude the topic on punishments. So if you are a student or if someone preparing for examinations, if you feel this video is helpful, do like this video, share this video among the friends whom you feel this would be useful, and don't forget to subscribe to my channel. Thank you.